Yo, what's going on? It's your humble correspondent, John Ross Marcus Cox, coming back to you with the Way Too Much JMC podcast. It is April 13th. It's around noon when I'm recording this. Hopefully I'll get it out. I'll get it published pretty quickly after that. I'm going to jump right into the topic. I don't know if hopefully y'all have read the show title, Kentucky's Kangaroo Court. And in the description it says, what if I told you that your state government, and in essence, I think this is going on in most states and even at a federal level. But what if I told you that your state government was ran by 10 people? So in Kentucky, we have 138 elected representatives between the House and the Senate. But what if I told you that 10 of those 138 basically control everything? Well, it's exactly what I'm telling you. And we're going to dig into that a little more here today. So, I know that many of my listeners have been, are pretty well in tune to the goings on of the state legislature here in Kentucky. And on that last day, and I talked about this some in the last show, several key legislators were removed from several committees. So, we had Josh Callaway removed from agriculture, education. We had Mark Hart removed from agriculture. Had Felicia Rayborn removed from agriculture, families and children, and health services. Had Stephen Doan removed from education and judiciary. Nancy Tate from families and children. Kimberly Moser from licensing occupations and administrative regulations. Again, Moser was removed because she called her colleagues Neanderthals on the House floor. Understand some disciplinary actions. For the rest of these people, it was in what we'll say is a revolt, although it's not what it was at all, to these powerful, the Power 10, in the legislature, and in this instance the Power 5 that's specifically in the House of Representatives. And real quick, we're going to go over here and I'm going to show you. We're going to watch a few things happening. And the stuff I'm about to show you, this all happened on March 15th, okay? So bear with me here. Hold on one second. So this is when it all started right here. Hold on. And this is Representative Josh Callaway from Breckinridge County and Hardin County. And discussion on Senate Bill 5 on March 15th. Let's listen to this for a second.
Think about what I am doing. Think about what I'm risking. I'm risking my political position. I'm risking friendships in here. I'm risking positions that I have, potential positions that I could have, and I am not intending to run for any big office. I have no intent to run for governor. I have no intent to run for a statewide office. And I am willing to stand right here, right now, and risk everything that I have for my children and your children.
So that's what started this. And what he's talking about there is he filed some amendments to Senate Bill 5. He filed these amendments to Senate Bill 5 because every other avenue of trying to get certain pieces of legislation and certain language through on other legislation was being stonewalled or just totally ignored. And we've talked about this already in the past. Okay, well that caused a series of events to occur. All right, and so the next thing I want to show you here is Mr. Josh Callaway here asking for a roll call vote on this amendment. So give me 1 second here. It may take it a minute to buffer, so we'll talk in between that. So first of all, notice you heard several people make the motion to hear it, and many and others to second it. So it's obvious that people wanted this thing to be heard after his impassioned speech that he gave on the Senate floor there. You also heard the words point of order. Okay, so that's important. Let's continue listening here for a second. Okay, so let's follow your Stephen Rudy. Let's talk about what germane means. Basically, the Constitution of the State of Kentucky states that any bill filed has to pertain to one thing and one thing only. Okay, and that it has to be defined in the title. Now, it sounds great, and I think most of us would agree that needs to be the case. But what that tends to lead to is people being creative on the title, okay, or just being super vague. But what it also tends to lead to is the fact that at the end of the day, whether or not something is germane, like, so if there's 5 topics, if there's 5 things being covered in the bill, if they're all, whether or not they're all pertaining to what that title says, is totally up to the discretion of the Speaker of the House. Okay, so let's keep listening. Okay, so there you have it. You hear what the Speaker of the House ruled there. Now, for those of y'all that are watching, you can see debate on SB 5, Senator Howell, an act relating to education and declaring an emergency. The only thing really that matters there is an act relating to education. Everything that the Speaker just pointed out that this amendment would cover only pertained to the educational system, the public educational system of the state of Kentucky. So everything in this bill was germane. And as I've said before, conversations have been taking place for 2 months, literally, hell, actually even longer than that. We might as well say close to 4 months of what HB 173 and SB 102 were going to encompass, which is basically what this amendment was getting those bills put into this one. The germaneness or the germanity or whatever you want to call it was never called into question, because that's why the bill was written the way it was, specifically to keep it to within the educational system. Okay, so SB 5's title was an act relating to education. These Josh's amendments all were unquestionably at least as related to the subject of education as SB 5 was in general. SB 5 was an obscenity bill. But guess what? Even if the amendment wasn't germane or hadn't been germane, there were 2 other title amendments in there ready to go that were an act relating to the protection of children and declaring an emergency, and an act relating to children. So ducks were in a row. T's were crossed and I's were dotted. And the following day, when SB 150 was finally passed, it also had language from 4 other bills in it that were having to deal with the same stuff that was just brought up there for the most part, but also trans transgender surgeries, transgender hormone treatments, transgender treatments. I mean, all kinds of stuff. And that was just an act relating to children. And when the Democrats challenged the germanity or germaneness of that bill, which I ain't gonna lie, was a reasonable challenge, totally reasonable, the same Speaker of the House deemed it to be germane. Let's keep listening for a second.
Speaker, I would ask that could there be a suspension of the so that it
And I want y'all to know something. I'm very speaker. I'm very speaker. I've been very fair to Speaker. I consider he and I to have a fairly good relationship. But there's no doubt that that was a low blow. We do not suspend the Constitution. I bet I could run circles around all of them on knowing the Constitution. But that simple question that Josh gave there should tell everybody that everyone was caught off guard by this ruling. I want you to keep listening so we can listen for the other member that brought up the challenge here that ended up getting everybody kicked off their committee. Then I'm gonna get to the point after that. So that was Representative Felicia Rayborn. I think she's from Trimble County, I believe, Henry County, one of those two. I apologize. I feel bad. I know most of them, but I don't have any idea what counties that they're from or districts or anything like that. Stepping up and if she wouldn't have did anything right then and there, that has been the end of it. Regardless of, you can't go back and say and convince people that it was that it was germane or whatever. That was it. Now that challenge right there, I'm just going to cut it off at that point. What Felicia Rayborn just did right there is why all those people were kicked off of those committees, because all these people, other than Kim Moser, were people that voted to overturn his ruling. Okay. Now, you may say, okay, where's the Kangaroo Court part of the title going to come into play here? I'm going to let you hear. So a Kangaroo Court, I'm going to give you a definition here, is an unauthorized, unofficial court, the sole purpose of which is to provide the image of a fair legal process. In actuality, the fate of the accused is actually decided in advance with no consideration being made as to the fairness of the situation. Kangaroo courts are typically associated with groups that practice their own brand of justice, which is outside of the formal judicial process. And then to explore this concept, consider the following Kangaroo Court definition. So, here's some definitions. A bogus court, the intention of which is to provide the illusion of a fair justice system where none exists, or a mob or self-appointed tribunal that mocks society's principles of law or human rights. The Oxford Dictionary defines it as an unofficial court held by a group of people in order to try someone regarded, especially without good evidence, as guilty of a crime or misdemeanor. In a less literal sense, it is used to refer to proceedings or activities where a judgment is made in a manner that is unfair, biased, and lacks legitimacy. A little bit more here. Bear with me. Kangaroo courts are systems that are set up to give the illusion of a fair and legal justice process, when in actuality they do not support unbiased justice. Instead, they often decide the fate of the accused in advance, usually for the purpose of securing a conviction. Here, what I'm saying is, our Kangaroo Court is something called the Committee on Committees. Okay? So going back to our Constitution, Kentucky Constitution, every bill that's filed must be assigned to a committee. Now, those of us that are normal, like human beings, they just assume that everybody's wanting to stay true to the spirit of the intention of something. You may think, okay, well, that guarantees all these bills are getting into a committee that pertains to them. No. Instead of every bill immediately getting assigned to a committee that would actually hear the bill, to circumvent the Constitution, they created the Committee on Committees, which is basically made up of leadership in both sides of the state Congress. So on the House Standing Committee on Committees is comprised of our Speaker of the House, our I think they call it the President pro tempore. I think they just call him the pro tem or something, or President pres tem or something. Okay, the caucus chair, the floor leader, and the majority whip. Then you also have the minority leader, the minority, I think, caucus chair, and one of the other, but the minority, even they don't really matter. They're outnumbered. And on the Senate side, it's your president of the Senate, your majority whip, your caucus chair, your floor leader, and I can't remember what they call the other one. But here, so in the House, it's David Osborne, David Meade, Suzanne Miles, Jason Nemus, and Stephen Rudy. And on the Senate side, it's Robert Stivers, Judy Rocky Adams, David Givens, Damon Thayer, and Mike Wilson. Those 10 people, the 5 on the House and the 5 on the Senate, are the Kangaroo Court. Okay, it is a body created to, anytime someone questions some kind of process or whatever, to give the illusion that it's all working out. So the fact, they would say that the Committee on Committees was created in order to abide by the Constitution and get every bill onto a committee so they can then devise them out and get them to the correct committees. So it goes, a bill for education would go to the Committee on Committees, then it would get assigned to the Education Committee. What they don't tell you is a whole bunch of bills never even make it to a committee. They just sit on the Committee on Committees. Okay? And because they're on the Committee on Committees, they made it to a committee and therefore qualifies for the constitutional requirement to put a bill on committee. Now, the Senate this year actually did assign all their bills out, but the House didn't, and I haven't heard anybody say they're planning on changing it anytime soon. Okay, now these committee members, they are elected. They are elected by their respective chamber, and they go around and they try to lobby to get people to get their chamber to vote for them and all that stuff. But a lot of times, I don't think these reps and senators understand the authority that they're vesting in these people, and they've never been given the opportunity to vote to not give them all that authority. So, in addition to deciding what bills make in the committee, all that, this committee decides what committees everyone is on, how many they're on, who the vice chairs are, who the chairs are, what bills will even make it into committee. So you may say, okay, well, there's a committee chair, so they're getting to pick the bills they want. I hate to inform you, they absolutely do not. They are middle management, and they take whatever bills that leadership tells them to. Okay, you may say, well, we can go out and get broad support for a bill, and it'll override this. Consider this for a second. HB 177, which is the parental rights bill that Shane Baker from Whitley, Pulaski County, filed. He was the vice chair of his committee. Had nearly 50 co-sponsors on it. His bill that he was the vice chair of the education committee for, and his bill that was an education bill, didn't even get a committee hearing. You know why? Because those 5 people said it wasn't going to get one. So that brings me back to SB 5 here I'm talking about with Josh Calloway and what happened in getting these people removed from their committees. Even though the argument had been made that the votes were there for this bill, stand alone, but also as an amendment, what had been told to the caucus was this. Now, this isn't any kind of like secret information here, that any amendments to this bill was going to kill it. Okay, nothing would get done. And they had effectively convinced people of that. But what they meant by that when they said it was going to kill it was that when this bill went back over to the Senate for them to concur with the changes, they were saying these 5 people, Robert Stivers, Judy Rock Adams, David Givens, Damon Thayer, Mike Wilson, what House leadership was saying was that those 5 people wasn't cool with it. Because guess what? We had also whipped these amendments and these topics and the standalone bills prior to this amongst the entire Senate body. But they're talking about these 5 people. And that's one of the things. It's like when you hear your reps, your senators, let your state reps email you back or talk to you and say, Senate wasn't going to, didn't agree with it or what have you. What they're really meaning is that leadership isn't okay with it. And by leadership, they mean the committee on committees and these 5 people in either direction. So that was the issue that came up on this bill specifically, okay? But this isn't even the half of why this is an issue and why I'm considering these 2 groups kangaroo courts. Okay, it's because of so I'm moving on from this one specific topic here on SB 5 and not trying to beat a dead horse. But what Josh Calloway did, what Felicia Rayburn did, what Mark Hart did, what Nancy Tate did, none of it was against leadership, challenging leadership. As you can see there, no one expected that to happen. And they choreograph everything everything before it goes to the floor. They choreograph all of it. There was one person that threw a curveball, 2. That was the full leader, Stephen Rudy, and the Speaker of the House, David Osborne. They threw the curveball, and they caused what happened in there. No one else. And I'm probably going to mess up my own relationships here saying this. But again, me having a relationship with them, if it's not resulting in good things happening for the general populace, what do they matter anyways? You all need to know the information. But there is no way they can say any of those people did anything wrong when there had been months in the making, and no one was telling them, do not call this amendment. Their plan all along was to let them call it, let them chit-chat on the floor a little bit, and then shut it down. And they didn't tell them how they were going to shut it down, and so nobody knew how to respond, and they just responded accordingly. Okay. Now, one person left that wasn't involved in this, that was removed from committees, was Stephen Doan. earlier in the session, he had made a motion to table a bill that the establishment, that leadership wanted through. Okay, it was a gray machine bill. They're going to ban these like gambling machines that were popping up in mom and pop shops, 7-Eleven, stuff like that. But the everyday average Kentuckian was actually making a little bread off of it. They were going to ban these things, and then basically only Churchill Downs and Keeneland were going to be able to make any money off of them. So he filed a motion to table this bill so there could be more discussion on it. And lo and behold, the motion passed. They didn't expect that, so they were doubly mad at him for that, and the fact that he voted to overturn the speaker's ruling on the humanity of that amendment. So that's why he got removed off. I tell you all this really for a couple things. For one really big thing, understanding legislative procedure is very, very, very important. And like, if you're not on this kangaroo court, you're going to have to learn it so you can use these things to your advantage. So you're going to study legislative procedure, study what's called the Mason's Manual, and use it to your advantage to advance your agenda, because this kangaroo court can do anything they want. Okay? And just take note, anything that you use out of that Mason's Manual that they don't agree with, they're going to, like, until other things are changed, they're going to use it against you. But if there's something you want to stop or try to advance or whatever, it's the only way you're going to be able to do it. No amount of transparency, no amount of organization, no amount of like good faith, stuff like that is gonna help you. If these 10 people don't want it to happen, it ain't gonna happen. Okay, but there is one thing that people can do, that our legislators can do, and that we actually can help them with. The chamber rules are also very important. And the votes for adopting those rules, and also the votes on who's getting into leadership are actually, probably the most important votes of any election cycle, honestly. I tell my kids in football all the time, like, you win the games in July when you're practicing. Like if you're winning games or you have a great season, that's just the byproduct. That's just the end result of successful practices in June and July. Same can be said here. If you get stuff through that you want and you're not part of the establishment, so if, you don't have to be one of the. Obviously, these 5 people are the only people getting a vote on any of this stuff, on who's getting to go into committees and all that. But like, if you're part of the establishment, you still got like a say. You're still at least getting to voice, put your input into the whole conversation without worrying about like retribution. Okay, but like this House rules package is what gives the Speaker the power to make rulings on germaneness, on whether a bill is a piggyback, so if it contains substantial text of another bill. Like, a lot of these decisions are just arbitrary. Okay, but this rule package is also where they can make a difference on who committee chairs are, who committee vice chairs are, what determines whether or not a bill gets a vote, that kind of thing. All right, and so there's a few things that I do think that we need to we should focus on, the reps and us as individuals, trying to like encourage them on steps forward. And I'll implore you to say this, like, until these things happen, until there are rules changes. So they ain't gonna get rid of any of these leadership people this session. They can maybe get some rules changes done. They won't be able to change leadership until after this next election cycle. But the reason I keep saying that, like, there's certain bills, and I'm not even going to talk about these bills yet because I'm trying to give everybody their wins or whatever. But until, like, until we deal with the Kangaroo Court situation I'm talking about here, where bills are predetermined to be good or bad, regardless of the merits, because they won't even read most of them. They just, the people around them tell them, their policy people, the swamp, tell them if it's good or not. Okay, but like even then, bills that get caught up that are good, these 5 people in each chamber will go in and arbitrarily just, they decide to pick up your idea or your topic. Okay, but they're going to change your language. Very few bills get through with the language that the original bill sponsor wanted. Specifically, they're going to change pretty key aspects of it normally. And that's basically how they say if you don't, it's not going to get a hearing. Then it's not going to get talked about. So, okay, it's like, all right, well, what do I do? So, most of y'all know me. I'm not just a complainer guy. I like to have some solutions. Let's talk about a few things they could do here. It makes no sense that these 5 individuals, this Kangaroo Court, can determine on its own the success or failure of any bill that any person brings forth. Y'all want to know why some of your most favorite legislators don't ever get anything heard in committees? Representative Maddox, Representative Rayborn, Representative Rawlings, Proctor, Callaway, Baker, Decker, Lockett. This year, Fugate and them got some stuff. You actually got some stuff in there, which I was very proud of. So, by no means am I giving you a full list of people here. Then you flip over to the Senate side. It's like Southworth, Senator Southworth. Ain't none of her stuff you can do. It's pretty good, usually. Senator Schickel. He'll get some stuff out of the Senate, but then it dies in the House. Well, it's because those 10 people, they got a little high school. It's like going to a really small high school where politics and all that's coming into play. It's petty. But there's absolutely no reason, no justification for these people controlling this. One rule change that absolutely should be numero uno, top priority. Any bill that receives a certain number of sponsors should get a floor vote on the original bill. Or maybe some variation based on maybe it gets a vote in committee. So these are just ideas. Problem right now is with committees, like they're tainted, but we'll talk about that in a second. But if you have a bill that's got 55 co-sponsors on it, and it only needs 51 to pass the floor, it absolutely is asinine that these 5 people can think, oh, these dumb East Kentucky hillbilly preachers, like they're going to do some crazy stuff in our government. We can't allow this to get through. And damn it, that is what they're saying at time. I mean, like I'm just telling y'all. I live both places. I see biases going both ways. But it's ridiculous that these 5 people can take it to their favorite policy person, totally annihilate a bill when there's 55 sponsors on it. Now, they would say, well, co-sponsorship doesn't mean anything. Co-sponsorship just means, they just want their people to see it, but they may not really want to vote on it. Well, the culture around co-sponsorship absolutely also has to change. And from my experience, it's only the people at the top that have power that are painting the picture that co-sponsorship doesn't mean anything. Everyone else, the rank and file legislator, knows that's the only way to show your voters what you believe in, and the only way to show your colleagues what you believe in. And so, therefore, we don't throw the baby out with the bathwater. If we need to change the culture around co-sponsorship, then we'll change it. And you know what would change it immediately? The culture around it. If co-sponsorship meant you better not be signing on to this if you don't want to vote on it, because if you sign on to it and it gets to the X amount of number of people, it's going to get a floor vote. So if you're lying, you're flying. So now I don't think it should have to be where there's 51 co-sponsors or whatever, or enough to pass the floor to get a hearing in committee. I think, like, I'm kind of suggesting something like, the number of members in the minority party plus 10. So right now there's I think 19 Democrats in our legislature. It's like 29 co-sponsors. I mean, it means it automatically gets a committee hearing and a floor vote. Not 29 will get you a committee hearing. If it gets out of committee, then it's automatically getting a floor vote. Okay. Then on the Senate side, it'd be the number of the minority, which I think is 6 plus 4 or 6 or something. You know what I mean? Let's say it's got to get 10 or 12 Senate. It gets a committee, and if it gets out, it gets a floor vote. But like, there's got to be a way to get it to where only these people are getting to control the language and the bills. And there's got to be a time frame. What is it? Within 5 days of that. Because something else in our Constitution is, technically, if a bill doesn't get heard in its committee, so if it doesn't get a hearing, technically they can go, any member can call that bill for a floor vote at any time and just say it wasn't called in a timely manner. Which brings me to my next thing. Probably need to codify that. What is timely manner? In my opinion, it should be like 5 days, or either 5 days or, 48 hours prior to the end of the, 48 hours before the veto period begins or something. It's got to be something to where, like, the bill would actually have a chance. So that good, broadly supported, sound, and from the people's house legislation can get heard. Okay, another big one for me is, like, when they're removing these people from these committees, every member, which represents people, actual human beings in the state, citizens of the state, should be guaranteed a certain number of committees. Okay? And they should be able to list, 2 or 3 or 4 that's their primaries, and they should be guaranteed to get on one of those. Like, people have expertise, they have things they care about. We don't want, there shouldn't be committees where everybody gets thrown on that committee because they know it's a BS committee, or they throw all the Democrats on that committee. Right? Like, and then all the Republicans they don't like thrown on that committee. Shouldn't be any of that going on either. But some of these people only got one committee now. Some of them have none. Adrian Southworth I think she has one. I think they have to have one, actually, right now. But this is also, like, again, they're representing constituents, thousands of Kentucky citizens. And these kangaroo courts, these 2 kangaroo courts, that are technically their own entity, but really are one big one, can just decide to be petty and totally disenfranchise 30,000 people. Another big one. Committee chairs. Okay, like, it seems like it'd be very special to be a committee chair, right? Like, you get to be the one that's controlling and, like, being the funnel for the best, so that the best legislation, the legislation that the state most cares about, gets into committees, whatever. Go back and watch. And what I'm saying right now, no one's ever said this stuff to me or whatever. It's just me, I'm good at reading people. If I get it wrong, I get it wrong. Go back and watch some of these people that were committee chairs and start with them on day one and see, and then go watch a hearing toward the end there. Tell me they ain't all mostly all frustrated. They don't get to call the bills they want to call. Okay, 2 sessions ago, they were railing on Savannah Maddox because she wasn't lobbying her bill to get it into the Senate for HB 28, the medical mandate bill. Why would you be lobbying a bill if it doesn't matter anyway? Why would you be lobbying the committee chair if they don't have the authority to call the bill. Because they don't. I do know this for a fact. I know on multiple occasions this session, because I was in the middle of choreographing it, there was agreement between primary sponsors on both sides on committee subs coming together and adding in some stuff to make it be a broadly supported bill. I know that the committee chairs knew about it. I know that leadership on the respective side knew about it. Actually, for one of them, I know they knew about it on both sides. I could pull out the receipts. But leadership, the committee on committees, the committees on committees, didn't want it to happen. So it didn't happen. And we're talking about specifically one that had to do with homeschool kids getting to get keys money, homeschool kids getting to participate in extracurriculars, and then making sure that they couldn't force kids to get the COVID vaccine. Okay, so Schickel, who had a bill that was passed 36-0, one of our state senators, agreed to let us put on homeschool extracurricular activities within the public school system and the COVID vaccine. That was sure to drop that 36-0 vote down some. He was like, these are good things that I think need to pass, and it's obviously the only way to get them through. Do it. We had the votes in the committee, the education committee on the House side. Committee chair was saying he was fine with calling a committee. They knew who the 12 members were that we knew for sure we had yes votes on. There may be more, but we knew we had 12, so it had gotten out. And worst case scenario, they pass that, it goes back to the Senate, they strip it down to what it was in the first place, and no harm, no foul. They didn't want it. They didn't like the fact they didn't choreograph it, and that the committee on committees, the Kangaroo Court of Kentucky, did not choreograph it themselves. They did not like it. Okay, so what's the solution to the committee chair stuff? You can't put up a vote for every committee member. So it's like this committee on committees is going to have some authority. I'm not saying strip them away of everything. It's like things got to be practical. We got to be pragmatic here. But once these committees are formed, let the membership vote on their committee chair and their vice chair. Let people that would like to try to be the chair go around and try to garner support. Have a non-voiced vote, or what do you call those? Whenever not an absentee vote, but it's like a silent ballot. And the best man or woman win. Top vote getter is the chair. Second vote getter is vice chair. Boom. Let them call their own bills. Give them actual autonomy, because the committees are actually supposed to be extremely important. And right now, you go look at Kentucky, you look at other states, you look at the federal level, like stuff will get out of committee, and you'll hear the people say, "Well, I'm being told this is going to get fixed before it gets to when it gets to the floor, so I don't like it, but I'm going to vote for it to get out of committee." That's stupid. That's where that's supposed to happen. The bill's supposed to get better in committee. That's like, I'm dumbfounded by those people that say that. I'm going to vote for it so it can get fixed. No. Is it going to be easier to fix it with 100 people doing stuff to it, or with the 19 people that actually care about the topic fixing it then and there, or it not getting out of committee? I actually don't have a problem with if there's a bill I'm pushing, if it gets voted down in committee, hey, it's the sponsor's fault and my fault, or the lobbyist, or whoever's trying to help the person explain it. Okay, and then one of the other big ones, and I have some other ones. This is the last one I'm gonna focus on right now. This is probably the one that's gonna be the most contentious, and this isn't just like reactionary because this just happened or whatever. Again, I think accountability, transparency, vulnerability to a radical degree are important, especially when you have egos and extreme financial interest and all involved, especially in those situations. But there should be an allowance for motions for any leadership position to be vacated by any member of the floor, any member of the caucus. Like I'm also saying, like you can't have a Democrat challenging a Republican to get removed. Of course, they would all do that. It would end up being like a procedural nightmare. But obviously nobody's going to challenge to remove the Speaker of the House because there would be obvious retribution coming from that, discipline coming from that. They're not going to do it if they don't think they have a good case, and that they don't have the support or the ability to voice their reasoning on the floor. So any member of leadership, I'd say no more than one time a week, can have a vacate vote brought by any member of the caucus. I'd also say that member should only be able to make that motion for that position, once a session or something. And then by a majority vote of their caucus, that member of leadership should be removed. And a vote for the replacement shall be conducted on that same day. On that same day, if they get a majority of their caucus. So right now there's 80 Republicans in the House, 30 in the Senate. If 41 Republicans in the House or 16 in the Senate vote to remove them, that's a pretty daggone big deal. Okay? And yes, it would be rare for that to happen. Again, because for it to happen, 16 people would have to piss off somebody with a lot of power. And if they miss it by one vote, all those people are going to get retribution and discipline coming their way. But again, it's a balance of power. It's what our founding fathers meant for it to happen. It's how they meant for it to happen. Okay, so again, I hate to beat a dead horse and keep talking about the same situation. With that Josh Calloway and Felicia and Mark and Steve and all them found themselves in. But it's just it's one of those situations to where, because it's the way things have always worked, it's easy for leadership to come back and tell people like you, well, you can't be challenged leadership like that. We talk about this stuff behind the scenes, yada yada, and it's easy for them to convince the rank, an average, everyday person that they did something wrong. But in this situation, the offending parties, specifically Josh Calloway, could not have been more transparent, not have been more thorough. I know this because I also was directly involved in it. And I'm radically transparent and open and thorough. And I do it, and I tell each of them, I don't even really care how you feel about it. That's just how I do business. I want to win the war of ideas. And in sales, if you're going to get a no, get it quick, so you can move on to the next one. My worry is if this whole situation doesn't have some kind of positive outcome, which I think it's guaranteed it's going to, even if they don't reinstate these people onto their committee positions, people see what's happening. But the worst case scenario is literally all the people that are left that believe in vulnerability and want to be honest and want to do things the right way and have high character and high integrity and all that, stop doing it and start, hiding stuff, and you'll see more dissent on the floor because of that. Because why would you tell leadership something if you know they're going to use everything in their power to shut you down? And there's no way to prepare your colleagues that, hey, there might be emotion on the germane nature of this. I need you to vote for it. It's Everything's happening too fast. Okay, but this is a perfect example of why people have to be more involved and have to do way more research, and we have to realize that there's stuff that we need to know that we haven't even thought about needing to know yet. Josh and Felicia and Savannah and Mark and everyone far and in between need us to also be well read on these procedures, on these House and Senate rules at a federal and state level, so that we can help them, because they don't have the swamp in their pockets and an endless amount of payroll helping them do the research and stuff. Okay, and I'm gonna end it with this, that this, just to tell you, this isn't only a state problem. Everyone was getting so mad at Matt Gaetz and those people that were not voting for McCarthy back during the speaker vote here several months ago. Y'all want to know why they held out as long as they did? And at the end there, whenever Matt Gaetz from Representative Florida, he didn't vote for McCarthy, but he voted president or whatever. When he finally voted president, he said why? He said the reason was because he couldn't think of anything else to ask for. And you know what he was asking for? Rules changes. Committee structures, the way bills get heard in committees, what causes bills to get floor votes? Can you challenge a leadership position and make a motion to vacate? All those things is what they were doing there. So the political apparatus is using this against us. They're using the rules, points of order, the Mason's Manual, gentlemen's agreements. They're using our good intentions and pure hearts and like Christian values, doing the right thing, trying to operate the right way with high integrity. They realized at some point in time that it was working, and the establishment wing of the Democrat and the Republican parties, the uniparty, this is what they're doing to us at every level. So we got to whip ourselves into shape, understand what's happening, and go attack it. And I think we got a good group of people in there now that are going to do that. And they definitely poked a bear with Felicia Rayborn and Stephen Doan. Listen, they're playing for keeps. Josh playing for keeps. Mark Hart's one of the nicest guys I know in the state of Kentucky. He's playing for keeps. Nancy Tate is a daggone warrior. But then the people that like them are as well. I mean, we have a good group. All right, and I'm going to be having some of them on here soon, hopefully, to discuss their backgrounds and that kind of stuff. But it's time for us to get engaged at a deep level. With that said, if you want copies of the House rules or the Senate rules, federal, state level, all you got to do is call Frankfurt or call Washington. You get a free copy of them. You want copies of maps of the districts and all that, you get a free copy of them. All right, so if you don't know how to do that, shoot me an email, jrmc@waytoomuchmedia.com. Look me up on Twitter, waytoomuchjrmc. Shoot me a DM there. All right. If you like the show, want to keep listening to it, look it up in Apple Podcasts, Spotify, Amazon, Google Podcasts, pretty much any of the audio ones that you listen to. Search Way Too Much JRMC. Search the same thing in YouTube or Rumble. Make sure you subscribe. Hit the like button. Leave me a comment, positive, negative. I don't care. Leave me a review, whatever. I need to hear from more of you. We got to support each other as grassroots, individuals and organizations. So, again,